lecture to celebrate Brussels School of International Studies' 20th anniversary, and it's wonderful to celebrate the evolution really of the school from, Yutaka was telling me, a single room up to a greater apartment and then onto this wonderful facility that we have here. So thank you to Yutaka, and especially a special note of thanks actually to Kimberly, who can't be here today, but who is one of our colleagues and is actually the person who invited me to come. So I'm very grateful to her for that invitation. I'd also like to really thank Tanya as well for her support over the last few weeks and months and her patience in putting up with me and my changing of my plans and delayed replies to emails. So I'm very sorry. And to Harm as well, who can't be here today, but I know who's very interested in my work as well. So thank you to all of you. So today I want to talk to you about stealthing, the so-called crime, or the so-called phenomenon of stealthing. And I want to ask, is it a crime? I'm going to argue it is, and I'm going to argue that stealthing should be called something else. It should be called non-consensual condom removal. And I'm going to explain to you why. So in recent years, societies across Europe and the world have witnessed a renewed focus on issues relating to sexual misconduct, particularly on the concerns of people who feel that the law does not adequately address their experiences of sexual harassment or sexual assault. Part of the political and social response has been to think about how rape law can be reformed. For example, Sweden has introduced a new law that criminalises sex without consent. Spain is doing the same. And in Germany, we've finally seen reform of the law, and I do say finally because it has been pretty outdated. Reform of the law on rape so that a victim who no longer needs to prove physical resistance, as unfortunately was the case under German law until recently. And so Ireland has introduced a statutory definition of consent in its law on rape, as has England and Wales and Northern Ireland. So alongside these developments around the law on rape and the importance of consent, in the last few years there has been an increasing public and media attention focused on the phenomenon of so-called stealthing. So stealthing is the act of having sex with someone without a condom after you have agreed to use one, essentially. So this covers a range of actions, such as the deliberate removal of a condom during sexual intercourse, or the deliberate breaking of the condom, or piercing of the condom, or damaging of the condom, or pretending to put on a condom but then not doing so. Okay? And so it's received quite a huge amount of media attention, from online forums to blog sites to mainstream media outlets like the Guardian newspaper. Teen Vogue has been really good on this, actually. Men's Health, Forbes magazine, CNN. It's difficult to convey, actually, just how many articles and blogs are out there and have been written about it. And a quick Google will confirm there's something like 1.8 million results if you search for stealthing. These posts and articles are generally about exposing the practice as something more and more women and gay men have experienced, and they explore the harms involved. Stealthing came to the public attention in the legal arena, really, in 2017, when a Swiss court convicted a man of rape for removal of a condom during sex and sentenced him to 1 year suspended sentence, which is quite lenient. I can come back to that point later. The parties had met via the dating platform Tinder and agreed to have sex at the woman's home. This is in the Swiss case. During intercourse, the woman refused the man's request to change to unprotected sex, only to discover later that he had in fact removed it. On appeal, the rape conviction was downgraded to the lesser but still significant crime of defilement, and the court upheld the sentence. Later in 2017, another event triggered even more public and legal interest in this problem. An article by Alexandra Brodsky, a researcher at Columbia University, attracted a huge amount of attention when it was published. It consisted of interviews with survivors in which they detailed what happened to them and how they felt about what had happened. It also involved research into an online forum where men talked about how to successfully stealth someone. And Brodsky studied an online community of perpetrators. So they're men who defend and give explicit instructions in the practice of stealthing. Some appeared to be motivated by the increased physical pleasure, others by the thrill from degradation, as one put it. Other studies have identified stealthing as a method of coercing a woman into pregnancy and as a means of intentional HIV transmission. All of these motives really fit with other studies which have found that hostility towards women is associated with the use of tactics by men to avoid wearing a condom. They're called condom use resistance tactics. I'm going to come back to that in a moment. So there's been a huge amount of media attention. There are proposals to finally or formally criminalise stealthing in Wisconsin and California. And in 2018, a German court, in December, just gone actually, 3 months ago, a German court convicted a man of sexual assault for removing a condom during sexual intercourse without the consent of his partner. So we're seeing convictions for stealthing. Now, that case is interesting because A, we have a conviction, but B, he wasn't convicted of rape because the court held that the stealthing was non-consensual, but the sexual intercourse was consensual. And this ruling is strange in that it separates the act of removing the condom from the crime of rape itself. And I would argue doesn't reflect the reality of the situation and deprives the conviction of much of its normative force. To date, there have been no convictions that I could find for stealthing in England and Wales. I have found 1 or 2 in Ireland, actually, but none to date in England and Wales. The term stealthing comes from the gay community, where it has been used for some time in relation to the intentional transmission of HIV. Excuse me. The term is problematic, I think, because it connotes games, fun, and it fails to capture the harmfulness of the conduct described. Stealthing, as a word, I think, foregrounds the actions of the perpetrators and not the harms perpetrated on the victim. It minimises the harms involved. I think we should use really this word of non-consensual condom removal rather than using the word of stealthing, because I think stealthing trivialises it. So this afternoon, in the time remaining, I want to set out the reasons why I think stealthing or non-consensual condom removal should be understood as rape. I will argue that it takes away the other person's choice to do what they want with their body, and as such is a disempowering act that violates a person's sexual autonomy. I'll use the idea of stealthing or non-consensual condom removal to explore the broader law on rape and specifically the law on consent to sexual intercourse. I want to show the harms involved in non-consensual condom removal and from there to show how the existing criminal law could be used to address this behaviour. I'll be exploring this question through the law on rape in England and Wales, which also applies to Northern Ireland as well. So Scotland has a different criminal law. Okay, so just to give you a sense of the outline of the paper, that's where I'm going with it. So beginning with harms and reform, a little history on the reform of rape law, current English law, and then the way forward, really focusing on communicative consent as a way forward in this area. So stealthing involves a number of harms. If we look at what survivors interviewed by Brodsky said, and if we look at the words of those who have reported their experiences to online fora and to journalists, survivors report a number of harms, some of which are bodily, some of which are psychological. So they include psychological distress, exposure to sexually transmitted infections, pregnancy, financial costs associated with disease testing. And apart from these fears and these bodily harms, all of the survivors experienced the condom removal as a disempowering, demeaning violation of a sexual agreement. That's a direct quote from Brodsky. So we can see that non-consensual condom removal involves the abuse of trust and privacy and the breach of the victim survivor's fundamental rights to sexual autonomy, dignity, and sexual expression. Yeah. So what is it? Let's drill down into it a little bit more. Non-consensual condom removal is a subset of what sex researchers call condom use resistant tactics. As you can see from the slide here, there are worryingly high rates, of course, of condom use resistance tactics. But you can see more generally, if we look at Davis's study, first on the left-hand side, that so they questioned, most of this work is done with undergraduate university students. And so this Davis and et al. Talked to heterosexual undergraduate students who were male, who had moderate drinking history and did not consistently use condoms. And 80% of them said that they successfully, I mean, putting that in inverted commas, but they successfully used condom use resistant tactics, which is extremely high, I think, and perhaps surprising. 30.8% of them used emotional manipulation tactics. 25% used deception, for example, saying that they would withdraw and then didn't. 1.6% successfully used actual physical force. So successfully means that it had the outcome intended, i.e. that condom wasn't used. And then 9% reported condom sabotage, which was removing it secretly or damaging it. And so again, I think that figure is quite high, worryingly high, and suggests that many women are having a kind of sexual intercourse that they have certainly not agreed to. In terms of specifically a study on non-consensual condom removal, there hasn't been really anything until this Melbourne study that was published by Latimer et al. On PLOS ONE. If you're interested, I have all the references at the end. And Latimer et al. Looked at 2,000 people coming through an STI clinic in Melbourne. And so again, this was up to people self-disclosing. So again, you know, there's questions there about people maybe not disclosing. But from this study, they found that 32% of the people asked, 32% of the women asked, and 19% of the men who have sex with men who were asked reported non-consensual condom removal. So that really surprised them. They were expecting a figure of around 2%. And certainly this figure of, you know, almost a third and a fifth of men and women, respectively, was quite surprising. So although the research on this phenomenon is still developing, we can say that a significant number of women and men who have sex with men are reporting being the victims of this behaviour. I want to now turn to the question of the criminal law's approach to non-consensual condom removal. So I want to really set the scene for you a little bit and contextualise the discussion by giving a little bit of detail on the law on rape and how it has evolved in common law over the past 3 or 4 decades, in the common law world over the past 3 or 4 decades. So for the past 30 or so years, feminist work on rape has focused on shifting the discourse away from the idea that rape was an act committed by a stranger on the victim. Feminists sought to tackle this myth by showing that rape is most often committed by husbands or partners, family members or acquaintances of the victim. They've also sought to challenge the myth that real rape involves physical force or the threat thereof. This kind of myth that real rape involves physical force was based on the long-standing idea that, you know, that female chastity was linked to male status, and the myth that women were likely to falsely allege that they had been raped. Feminist reform efforts instead focused on reforming the law to reflect the core harm of rape as one of a violation of the victim's agency and autonomy. Therefore, emphasis on bruises or other physical injury became less important evidentially, and the law has focused on whether consent has been given or not to the sexual act. So over the past 4 decades or so, consent has worked reasonably well to draw out the wrongfulness of rape, to make sure that the crime encompasses the invasion of a person's sense of self. And you can see that shift from force to consent by comparing the common law definition of the crime with the statutory definition of the crime in the 1976 Sexual Offences Amendment Act. So here I'm focusing on the English law, but on the left, your left-hand side, you can see the common law definition. Blackstone wrote it down in the book in the 17th century. The unlawful carnal knowledge of a woman forcibly and against her will. So you see that element of force being there at the heart of what rape was. And then under the 1976 Act, you see there's no mention of force and the focus is on consent. Okay? I'll bring you bang up to date with the current law in England and Wales and Northern Ireland, which is the Sexual Offences Act 2003. And so that says a person commits an offence if he intentionally penetrates. So the he is generally gender neutral in all acts, but here it has to be male. because it's focused on the penis, which hasn't been mentioned up until now, until this piece of legislation, which is also interesting. So he intentionally penetrates the vagina, anus or mouth of another person with B, with his penis. B does not consent, so you see consent there, and C, A does not reasonably believe that B consents. So there's a lot there. But you can note, first of all, that consent is at the heart of the definition of rape. The definition of rape was widened to include penetration of the anus or mouth. And you can also see there under subsection 2, this question of belief and consent is dealt with quite explicitly. It's quite a radical provision as well. It says whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps A has taken to ascertain whether B consents. So if somebody says, yeah, okay, well, the other person didn't consent, but I thought they were consenting, that's not enough. The court will look for more than that. They will say, well, why did you think they were consenting? Was it reasonable? And so in England and Wales, they'll ask, was it reasonable that you thought they were consenting? Okay, so the Act also introduces 2 categories where consent and belief in consent are conclusively presumed to be absent, where the defendant intentionally deceived the victim as to the nature or purpose of the act, come back to that in a sec, and where the defendant intentionally impersonated a person known to the victim. So we have that conclusive presumption, and essentially that means that if the circumstances in this section 76.2 can be shown to have existed at the time, then the jury can conclusively presume that consent was absent, and also that the defendant did not believe that their partner consented. This is a really technical, I understand, but also just to get the point across, it's a very powerful weapon for the prosecution in that effectively it removes a defence. If those circumstances are satisfied, they don't have to prove anything in relation to consent, and they don't have to prove anything in relation to belief in consent, or lack of belief in consent for the prosecution. Okay. For stealthing cases, the relevant subsection for us is that 2A, the defendant intentionally deceived the complainant as to the nature or purpose of the relevant act. So many of you might be wondering, well, what's the difference between nature and purpose of sexual intercourse? There is no logical or real difference here, and I'm not going to bother going into why they've put this down. It's essentially a remnant of common law. It's a legal fallacy. It's very difficult to see the difference between nature and purpose, essentially. So you might ask, well, would that cover cases of stealthing? It's certainly very easy to imagine a lawyer making the argument that removing a condom during sex involves one party deceiving the other as to the nature of the act that they are engaging in. So, you could easily imagine that it would cover it. But to make a long story short, the Court of Appeal has interpreted Section 76 in a very limited way, so that only a very limited number of cases involving a deception as to the essence of the act are covered. And instead, the courts have preferred to use a different section, which is Section 74, which applies to all cases of all sexual offences. It's actually a statutory definition of consent. And so we don't have any conclusive presumption operating in cases of stealthing, but we still have the Section 74 to look at. So that's where I'm going to focus the rest of the talk on, essentially. So Section 74 says a person consents if he agrees by choice and has the freedom and capacity to make that choice. So for the first time in English law, we have a statutory definition of what consent means, and it gives, I guess, the prosecution, it gives the jury something to hold on to when they're trying to understand, well, was consent given or not? Okay. And there are only 2 cases, you'll be happy to know, that deal with stealth, or maybe not happy to know, but that most clearly deal with stealthing in English law. And these are the only authorities we have to date, and neither actually involved an actual conviction for stealthing. They're both judicial reviews where the courts are giving an opinion as to whether or not stealthing would be a crime under English law. Okay, so Assange, many of you, I'm sure all of you know who Julian Assange is, do you? Okay, great. Julian Assange, WikiLeaks founder, he basically challenged his extradition to Sweden. Have any of you heard of this case? where he challenged his extradition to Sweden. Yeah. Okay. So basically, he was charged with unlawful coercion, sexual molestation, and rape. And he was in England at the time, and he challenged his extradition through the European arrest warrant system. He was challenging his extradition to Sweden on those charges. So he took a case essentially that ended up in the English High Court. And I'm going to focus obviously on the charges of sexual molestation and rape here, which are most relevant to our consideration of the law and stealthing here. Both of these cases involve the cases involve two different women, and both of the cases involved him having sexual intercourse with each woman without a condom when he knew that a prerequisite of intercourse was that he would wear a condom. Therefore, the allegation was that deliberate removal of the condom is what took place, so that it wasn't accidental removal. Okay? Mr. Assange's lawyers argue that consent to sexual intercourse, on condition that he wore a condom, was still consent in English law. Okay? Even if he had not used one or if he had removed it or damaged it. So the High Court had to decide if that kind of behaviour, which we are calling stealthing or non-consensual condom removal, could be criminal in England. And really this was a theoretical exercise in lots of ways, as I say. They weren't an appellate court. They weren't deciding on the rightness, the correctness of a conviction. But they rejected Assange's argument that it did not matter that she had consented only on the basis that he used a condom, because that did not change the nature of the act. That was his argument. They said, actually, it certainly could be considered under Section 74 when the jury was considering whether there was free or voluntary consent on the part of the victim. Okay? So they're basically saying, we're not going to let you argue that there's a conclusive presumption that arises, because that would remove the defence from the defendant, and we're not happy with that in this circumstance. But we are going to let you argue, we are going to let the matter go to the jury, and the jury can decide whether or not consent was given. And we're going to allow the jury to consider Section 74. So we know then, so he hasn't actually been extradited, but it actually went on to the Supreme Court, and he hasn't been extradited to date. But that case at least tells us that there is a possibility of criminalisation for that kind of behaviour in English law. The second case I'm going to talk to you about is F and the DPP, and that's a judicial review of a decision not to prosecute. So the CPS lawyers decided, the prosecution decided on the basis of the evidence not to prosecute. And actually, the applicant here was asking for a judicial review of that decision, which is rare but is possible in English law. So the evidence from the victim, who was a university student, was as follows. After her Islamic marriage to F, so she is A. So after her Islamic marriage to F, their relationship was marred by his abusive dominance. For example, he would often put his hand on her throat during intercourse, and he would call her bitch. The victim stated that as the relationship continued, he felt that she did not have the right to say no to his demands. Although she tried to leave, she would always come back because she felt and hoped that he would change. And the judgment details a number of specific incidents where F emotionally and physically abused her into sexual acts. The incident that the High Court focused on took place in a bathroom. So essentially, at this point, F knew that she did not want another child. She already had one. However, she could not use the pill because it was unsuitable for her, and he didn't like using a condom, so they agreed instead that he would withdraw before ejaculation. After a disagreement, but then an apology from F, she put her arm around him. Then F turned her around over the basin and pulled her pyjamas down and penetrated her vagina with his penis. She did not object, provided he withdrew before ejaculation. So, shortly after penetration and without allowing her any chance to object, he told her that he would be coming inside her. And he said, because you are my wife and I'll do it if I want. And then he ejaculated before she could do or say anything. She became pregnant as a result. So the court really focused in on the dominating and controlling way in which F treated her. And that's clear from an email she sent a month after the incident, which you can see up there on the slide. You can also see text messages which were admitted into evidence from F, where he's showing that he admitted his dominance of his wife. He also apologised for raping her, but it's not clear what incident that referred to, so that wasn't much help. Giving the court's judgment, the Lord Chief Justice analysed the incident involving the ejaculation without a condom, and they analysed it against that background and context of the abusive relationship. They found that there was evidence that he deliberately ignored the basis of her consent as a manifestation of his control over her. And this is important for our purposes. They found that choice was at the heart of consent, and they found that in this case, it was clear that there could very well have been a lack of consent. So they ordered a judicial review. So I don't know whether there's been a subsequent prosecution. I haven't found evidence of one. But what's clear from F and what's clear from Assange is that the courts in England and Wales are really clear that, and that's the decision there, the courts are really clear that sex with someone who has made clear that a condom is required, if that condom is then removed or never put on in the first place, would be an offence. But that's not the end of the story. So there is a problem for prosecutors and for anyone who's interested in seeing this kind of behaviour being prosecuted as rape under the current legal framework. First of all, I mentioned Section 74, the definition of rape, or the definition of consent. That's been heavily criticised for being vague and leaving too much up to the discretion of individual judges when directing a jury. This is really problematic because it leaves open the risk that juries will not understand the importance of sexual autonomy because the judge has not clearly explained it to them. In this context, it's really important to remember the cultural and social context in which rape trials take place and the relevance of broader societal attitudes to rape and sexual behaviour and how they influence lawyers' presentation of the issues and the adjudication of these by juries. Really, I think leaving it up to Section 74 to do all the work without adequate guidance on what the contours of consent means, really that results in hierarchies of victims being created, and it's possible that different standards will be created for different classes of victims. This is really because of the influence of rape myths on juries, so juries may wrongly continue to look for things like resistance in a case of stealthing, or they may only criminalise in cases where bodily harm is evidenced. For example, a person's made pregnant or contracts a disease following the non-consensual removal of a condom. And certainly in Canada, the current position is that consent is only vitiated by condom sabotage if accompanied by a significant risk of bodily harm. So this might seem fine, but actually that would exclude women who cannot bear children. It would exclude women and men who are victimised by a man who doesn't have a communicable disease. And so really we want to see something like sexual autonomy not being linked necessarily and definitively to bodily harm and psychic harm only. So it's far from clear that the courts are up to the task of investing the idea of consent under English law with adequate meaning to address the reality of women and men's lived experience of stealthing. In order to better protect women and men and to use Section 74 to better reflect the harms involved, it may be necessary for the courts to provide more detailed guidance on what consent means. And one way forward is for courts and for lawyers to think more carefully about what consent means and what sexual autonomy means. You might think about reimagining it. The harm at the heart of stealthing is the refusal to take consent seriously, and more specifically, it's the failure by a man to take their partner's sexual autonomy and agency seriously. The refusal is, to put it more clearly, to take the woman's decision or the other man's decision about her or his body seriously, or to put it another way, a refusal or a failure to take a person's autonomy seriously. And under this approach, the focus is on the value of a person's right to choose what to do with their body and to choose what sexual experiences they want and under what conditions. The focus is less on the physical act and more on the violation of the terms of consent. This is more in keeping with the move in legal feminist theory and in law reform away from force and towards consent as indicative of the wrong of rape. So how might we go about thinking through the ways in which we might want to criminalise stealthing by giving it a fuller account of what consent actually means? I wish to suggest that a fruitful line of inquiry would lie in the communicative consent model. It has influenced law reform in the UK, as well as Australia, Canada, and New Zealand. The model views consent as a continuous process of mutual decision-making. It recognises that there are multiple decisions to be made in sexual interactions. So kissing, for example, is not in itself consent to sexual touching. Furthermore, because desires can change, consent can change or be revoked. Now, all of that is something the law already recognises, but the communicative model really takes this and takes it more seriously, I think, than the current legal position. It seeks to shift attention away from questions like whether the woman resisted sexual advances, to questions such as what steps did the man take to ascertain consent. Building on work by two Australian academics, Gail Mason and James Monaghan, I'm arguing that communicative consent is concerned with autonomy and with responsibilities. So at the heart of the conception of autonomy is a concern for people's capacities to authoritatively imbue their words and actions with meaning. A key part of the meaning of sexual autonomy, then, is being able to make your words and your actions what you intend. To be respected as someone whose yes means yes, and whose no means no, and whose no does not mean yes. Corresponding to this concept of autonomy is what Mason and Monaghan call epistemic responsibility. This means that sexual partners have a responsibility to know what each other's ends are in engaging in sex, to know how to go about attaining those ends, and not to act contrary to the other's desires. Importantly, obtaining this knowledge requires communication. So, epistemic responsibility and autonomy are two sides of the same coin. Part of being a responsible epistemic agent is respecting the other as someone who can authoritatively imbue their actions with meaning and taking steps to ascertain their desires before engaging in sexual activity with them. So, we might want to think about that definition of consent that I mentioned. A person consents if he agrees by choice and he has the freedom and capacity to make that choice. That's the definition under Section 74. He meaning he or she in the statutory language. So agreement by choice and freedom and capacity. So using the communicative consent model then, we can say something more about it, about Section 74 and how it might apply to non-consensual condom removal. First, we can say that the emphasis on agreement and on choice reflects the communicative ideals of autonomy and mutuality. A communicative consent reading of the section would say that consent is a positive state of mind. It's something that is to be sought and to be communicated or not communicated and not assumed. It's also clear that the agreement should be voluntary and that acquiescence is not the same as consent. So it's well established in psychiatry and psychology that people freeze when they're raped. They dissociate. Therefore, if a woman or gay man were to freeze or not say anything when they noticed that the condom was removed, if they noticed at the time, that should not be taken as indicative of their consent. The idea of an agreement under the communicative consent model also involves understanding of the material facts. In the case of stealthing, we would say that the lack of knowledge that intercourse will be without a condom would constitute a lack of understanding of the material facts about the sexual act that they're about to engage in, or they are engaging in. Agreement would also involve a second limb, and that's communication. This would require the man to take steps to ascertain whether consent was present. So for present purposes, at a minimum, this would mean checking to see if their partner was happy for them to remove the condom. A defendant who has unprotected intercourse with someone who has only agreed to sex with a condom cannot then have met the threshold of epistemic responsibility that the communicative model sets. Incomplete information, like not knowing your partner has removed a condom, makes a yes not really a yes. A more expansive version of this would be placing an onus on men to check clearly beforehand if their partner is happy to have sex with or without a condom. And so I didn't spend a lot of time on it today because I don't have time, but the provision in the Act that talks about the person who is doing the penetrating, the man who's doing the penetrating, must have a reasonable belief and consent, and that the court will look at the justifications for why somebody may say they have a reasonable belief in consent. Well, that provides us with a platform on which to launch that kind of an argument around communicative consent and specifically communication. So did you check or not? Okay? So, rape discourse is changing and reflecting the reality of women's experiences and men's experiences of subordination and dehumanisation. The law on rape has changed considerably over the course of the past 30 years. However, we still have some way to go in making the legal concept of consent and the idea of autonomy on which it rests really reflect the realities of women and men's lives. By naming this behaviour of non-consensual condom removal and the harms that it causes, it becomes visible, and the taken for grantedness of such behaviour may begin to be challenged. As Liz Kelly noted in her path-breaking book, Surviving Sexual Violence, naming involves making visible what was invisible, defining as unacceptable what was acceptable, and insisting that what was naturalised is problematic. Non-consensual condom removal during sex, damaging a condom before using it, or pretending to wear one but deliberately not doing so, are all practices that are acts that violate the other person's sexual autonomy and agency. In order for the criminal law to respond effectively to rape in this way, the courts need to think more carefully about what consent means. The idea of communicative consent, I would argue, is one way which may provide a useful way of doing this. Thank you very much. Thank you.
Thank you very much, Sinéad. This is a wonderfully fruitful and inspiring and very richly dense lecture. Now, from the point of view of international law, some of you who have taken international human rights class, you may know that there's a public discourse on the distinction between the private and public, and how the international legal theories from the 19th century in the post-Enlightenment tradition have emphasized more on the public domain, so that we tend to kind of preclude what we consider as a kind of a marginal, quote-unquote marginalized private domain of women's spheres of international law. And so this is something that current critical feminist theories are now trying to shed light upon at this moment. So in that sense, Sinéad, his work is very much feeding into this in this conceptual framework, very much. And I guess some of you, some of our audience are, or in fact, most of them audience are not lawyers, in fact, and they're not familiar with the concept of marital rape as such. So perhaps, you can also just, in question and answers, you can also just explain about the marital rape, how this concept was actually, recognized in the context of, the British case law, and then went on to Strasbourg, European Court of Human Rights, and so forth. Yeah, but anyway, perhaps,